Hey guys, just me again. We're going to put a trigger warning at the top of this episode because it deals with a sensitive subject. If this isn't for you, no worries. Skip on ahead to another episode. Please take care while you're listening and protect your own mental health. Hey, welcome to Legal Listening, where audio Obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy! The Queen and W.M. Court of Appeal for Ontario. Heard March 6, 2020. On appeal from the conviction entered on May 30th, 2017 by Justice John R. Sproat of the Superior Court of Justice. Chief Justice of Ontario, Strathy. The appellant appeals his convictions for sexual interference and sexual assault of his daughter, who was approximately 4 years and 10 months of age at the time of the offenses. A stay was entered in relation to the second count. He was sentenced to 4 years imprisonment and ancillary orders were made. For the reasons that follow, I would allow the appeal and order a new trial. The evidence. The child's mother testified that the incident came to light after the Children's Aid Society informed her that the child had engaged in sexualized behavior at school. The mother had some knowledge of her husband's past, discussed below, which prompted her to ask her daughter, quote, "Did Daddy touch your vagina?" End quote. The child replied, yes. The mother told the child that if her father ever touched her again, she should run and get her. The mother ultimately notified the police and the appellant was charged. Shortly after the alleged incident, the child made a video statement. It was admitted in evidence at trial and she adopted it as true. She said that her father had touched her vagina with his hand over her pajamas while he was standing beside her bed. She claimed that she had screamed for her mother, who came into the room and said, "Did Dad touch your vagina again?" She replied, yes. In the course of trial preparation, the child disclosed a second incident, in which she alleged that the appellant had touched her vagina with a spoon or a round object. At trial, she said that she was in bed sleeping when the appellant, who was standing beside her bed, pulled down her pajamas and touched her vagina. She did not see the spoon, but the object was metal, smooth, and circle-shaped. She said that the spoon incident took place when she was 5 years old, and that it occurred before the touching with the hand. She said that she forgot to tell the officer who took her statement about the touching with the spoon. There were some inconsistencies in the complainant's evidence. This was not surprising in view of the child's age when the events were alleged to have occurred, and the passage of about 2 years between those events and the trial. There were also some inconsistencies between the mother's evidence and the child's. The appellant testified and denied the allegations. The trial judge admitted similar fact evidence of offenses that the appellant pleaded guilty to in 1998. A. Between 1985 and 1987, when he was 13 to 15 years old, he sexually assaulted a 3 to 5-year-old child he was babysitting, lifting her nightclothes and touching her vagina. Between 1995 and 1997, when he was 23 to 25 years old, he sexually assaulted a 5 to 7-year-old child, going into her bedroom while she was sleeping, exposing her body and touching her vagina. In addition to convictions for the offenses above, the appellant testified that he was convicted in 2000 for dangerous operation of a motor vehicle, possession of proceeds of crime, and break and enter. He was convicted again in 2008 for possession of a weapon, assault with a weapon, and theft under $5,000. The appellant testified that he himself had been sexually abused as a child while in the care of CAS. He said he knew what he was doing was wrong at 13 to 15 years old, but he did not appreciate just how wrong it was. He said that he better understood the wrongfulness of his actions in 1995 to 97, when he was 23 to 25 years old, but nevertheless did what he knew to be wrong because of the sexual gratification he received. However, the 1998 conviction drove home for him how wrong it was. He testified that he was a changed man as of 1998 because of his better understanding and his resolve to change. The appellant testified that he had received sex offender treatment while in custody at the Ontario Correctional Institute for the 2000 convictions. He testified that prior to commencing the sex offender course, he underwent phallometric testing, and his understanding of the results was that he was not a pedophile. He also said the treatment helped him to learn how to better understand the feelings of others, to be accountable to the victims, and to learn how to empathize, to have victim empathy. He looked at his own triggers and stressors and why he did what he did. In addition, the appellant testified that as a result of the motor vehicle accident that resulted in his 2000 conviction, he had suffered physical injuries that affected his ability to get an erection and left him unable to experience sexual gratification in the way he had before. In cross-examination, the appellant testified that he did not have any concerns about reoffending because of 1, his increased appreciation of the wrongness of his actions as a result of the 1998 conviction and the 2000 sex offender course, and 2, the physiological changes in his body as a result of the 2000 motor vehicle accident. The trial judge's reasons. The trial judge correctly described the principles in the Queen and WD. These principles apply to the assessment of evidence in cases of sexual assault and outline a common-sense approach for assessing the evidence of young children, while at the same time respecting the presumption of innocence and the burden of proof in criminal cases. The trial judge found that the complainant was credible, in the sense that she wanted to tell the truth. He found that the child's mother did not influence the child's evidence, either intentionally or unintentionally, and that the allegations of touching came from the complainant and not from her mother. The inconsistencies between the evidence of the mother and the child did not cause him to doubt the main points of the child's evidence. The trial judge noted that the appellant's cross-examination disclosed aspects of his evidence that were self-serving or exaggerated or contradictory. For example, he claimed that he was unable to achieve an erection after the motor vehicle accident in 2000, but it was pointed out to him that he had been able to father a child, the complainant, after the accident. He also initially claimed that he did not realize that touching a child's vagina was wrong when he was a young person, but acknowledged that the acts were done in private so that he would not be caught, and ultimately agreed that he knew it was wrong. In commenting on the appellant's evidence in relation to similar fact evidence, the trial judge observed, quote, he was asked if he had any concern of reoffending after 2008. He said the sex offender treatment and other programs he took at the Ontario Correctional Institute in 2008 were such that he did not have a concern about reoffending, end quote. In assessing the weight of the similar fact evidence, the trial judge said, quote, I accept and take into account that the appellant received sex offender treatment while he was incarcerated. That evidence logically does tend to diminish the significance of the situational specific propensity that the appellant had demonstrated in the conduct underpinning his convictions for offenses in 1985 to 87 and 95 to 97. I do note, however, that implicit in the appellant's evidence that he received and benefited from sex offender treatment in 2008 is that he still had some need of treatment at the time. He still needed to manage his impulses and learn to empathize with victims and learn to recognize triggers and stressors that lead to this behavior. In other words, the situation-specific propensity that demonstrated itself in 1985 to 87 and 90 to 97 was also present in 2008. Given that this propensity persisted or at least demonstrated itself over the period of 1985 to 2008, there is every reason to believe it would still be a factor in 2015. No one would suggest that any treatment program is 100% effective. So while I factor the treatment program into my analysis, it certainly does not preclude consideration of the long-standing situational specific propensity that the appellant had to touch female children inappropriately. The significance of similar fact evidence lies in the improbability of coincidence. I think there is virtually no chance that coincidence explains the appellant having a criminal record for touching prepubescent females on the vagina while they are in his care and sleeping, and this complainant making the same allegation," end quote. Ultimately, the trial judge did not accept the appellant's denial of the allegation and stated that the Crown evidence he accepted satisfied him of the appellant's guilt beyond a reasonable doubt. Grounds of appeal. The appellant raises 3 grounds of appeal. 1. The trial judge erred in his application of WD and misapplied the burden of proof. 2. The trial judge's reasons were insufficient in that they failed to adequately address inconsistencies in the Crown's evidence. And 3. The trial judge misapprehended the appellant's evidence concerning his sexual offender treatment, and this error had a material impact on the conviction. As I would allow the appeal on the 3rd ground, I do not find it necessary to address the other 2. Analysis. 1. Legal principles for misapprehension of evidence. A new trial is required when the appellant has met the stringent standard for determining whether a misapprehension of evidence resulted in a miscarriage of justice, as set out in the Queen and Morrissey. Specifically, the misapprehension of evidence must go to substance rather than detail. It must be material rather than peripheral to the reasoning, and the errors must play an essential part, not just in the narrative of the judgment, but in the reasoning process resulting in conviction. If the appellant can show that the conviction was based on a misapprehension of evidence, the appellant is entitled to a new trial, quote, even if the evidence, as actually adduced at trial, was capable of supporting a conviction, end quote. The impact of a misapprehension of evidence is particularly marked in cases where the principal issue is credibility. In such cases, it is essential that the findings be based on a correct version of the actual evidence, as wrong findings on what the evidence is destroy the basis of findings of credibility. 2. Application. A. The factual error. The trial judge's reasons quoted above at paragraph 17 contain a misapprehension of the evidence. The uncontested evidence was that the appellant received sex offender treatment in the Ontario Correctional Institute while he was in custody in 2000, not in 2008. Based on the factual error with respect to the date of treatment, the trial judge also found that it was implicit in the appellant's evidence that he still needed treatment in 2008, 10 years after his previous offense. B. Impact of the misapprehension of evidence. The misapprehension of evidence affected the trial judge's reasons for conviction in 2 interconnected ways. 1. It led the trial judge to find that the appellant's propensity to offend was likely active in 2015 when the offenses were alleged to have occurred. And 2. The trial judge found implicitly that the treatment did not reduce the probative value of the similar fact evidence. Propensity to offend in 2015. The trial judge found the fact that the appellant required sex offender treatment in 2008 was evidence that his propensity was still active in 2008, and therefore the propensity was likely active in 2015 at the time of the charged offenses. This factual error led the trial judge to believe that there was evidence of an ongoing propensity that persisted for a 23-year period, from 1985 to 2008. This mistaken finding of fact factored into the trial judge's rejection of the appellant's evidence that he had benefited from treatment and was confident that he would not reoffend as a result. Under the correct timeline, the appellant's evidence, including his claim of confidence, would have been more credible. Properly understood, the evidence demonstrated that the appellant had received sexual offender treatment in 2000, within 3 years of his previous offense in 1998. Furthermore, the propensity had not demonstrated itself in the 15 years after treatment. Weight of the similar fact evidence. Second, the factual error affected the weight of the similar fact evidence. This is because the treatment could be viewed as an intervening event that diminished the probative value of the similar fact evidence. The trial judge correctly recognized this in his reasons, stating that treatment logically does tend to diminish the significance of the situational specific propensity. However, the factual error would have impacted the trial judge's assessment of treatment as an intervening event. In analyzing the similar fact evidence, the trial judge considered how much time had passed between incidents of demonstrated propensity. As discussed, the trial judge reasoned that the propensity exhibited in the similar fact offenses was still a factor in 2015 because of the factual error that the appellant received sexual offender treatment in 2008, only 7 years before. This line of reasoning would not have been available on the correct timeline of treatment in 2000. In actuality, the appellant had received treatment 8 years earlier, meaning 15 years had passed between treatment and the charged offenses, more than twice as long as the trial judge believed. This is a material length of time that would have affected the trial judge's assessment of the appellant's evidence that he had benefited from treatment, and relatedly, the extent to which treatment could be considered an intervening event that diminished the probative value of the similar fact evidence. I am satisfied that the appellant has met the stringent standard for determining whether a misapprehension of evidence led to a miscarriage of justice. In the present case, the similar fact evidence played a significant role in the conviction, as did the trial judge's discounting of the appellant's evidence concerning the effect of the sexual offender treatment. The misapprehension of the evidence was material and played an essential part in the trial judge's reasoning process. In cases predicated on credibility, such as this one, it is essential that the findings be based on a correct version of the actual evidence. I would allow the appeal and order a new trial. Chief Justice Strathy, with Appeal Justice Trotter concurring.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.